dear beloved Creator of all that is, we feel and express our gratitude for our very being and for our awareness of your unconditional love and presence in our lives. So we thank you, and we honor you when we stand up and recognize that all power is inherent in the people, created in your image, for we know and value the gifts you bestowed us with. We feel gratitude in knowing that when faith is held by the people know they are the ones who empower their government, and that it is up to the people to manage its control and progress. Let it be so, and so it is.
Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. A solution is not difficult. The return to Article 4, Section 4 of the United States of America's Constitution. Unlike Richard, you probably don't have it memorized, so I'll read it. Article 4, Section 4. The United States, that's the de jure United States of Washington District of Columbia, not the de facto incorporated bunch that's there now, but the United States shall guarantee to every state in this union a republican form of government and shall protect them against invasion and on the application of the legislature or of the executive when the legislature cannot be convened against domestic violence. Okay? We have to be able to get there. And what took us 4.5 years to accomplish on Oregon can be done by a Jural assembly of 5 or 6 in 15 hours work, $60 for postage, $40 for a seal, file all the paper at the same time, and in 30 days it's a fact. Use your time waiting to gather your jury pool of men and women to populate your grand jury, your petite jury, your clerk of court, your marshal, and provisional government on your state, commonwealth, or territory. We have an action committee in our Jural Assembly, no more than 12. And we number several hundred now. We've had 6 grand juries, 5 petite juries with presentments and true bills, court's orders, and claims of cognizance. And it's all published at www.orsja.org. And what this is about is there is no law out of the United States of Washington District of Columbia. It went ink in 1871. That is not original jurisdiction. It is de facto. It cannot call an Article 3 court claiming original jurisdiction over a man or woman with their progeny on the land and soil of their state, commonwealth, or territory without ruler or subjects. That court is found in Amendment 7, where the value is more than $20. It is common law with a jury verdict that has no appeal in fact. That is a de jure civilian court of record having implemented Ex parte Milligan and eliminated the United States federal district courts on Portland and Eugene on Oregon, 18 U.S.C. 242, color of law. We have also abolished the judiciary of the state of Oregon, aka all caps state of Oregon. They have all acquiesced to being without a proper oath to a proper constitution with God included. There are 33 states and commonwealths. The state of Oregon's legislature, 89 in total, were all convicted of oath breaking, and they have no honor. As was the executive branch, they cannot hold a position of trust. They were convicted in our Article 3, Amendment 7 Civilian Court of Record. Original jurisdiction has not been constituted since South Carolina seceded from the Confederation and Perpetual Union's constitutional Republican form of government, December 1860. December 24th, 1860. Guaranteed to every state among the several states of the United States of America, except on Oregon. We have returned Oregon to de jure. Now I lost my place. Uh, we cannot have de jure while there is color of law de facto incorporated defunct bankrupt usurpers still ensconced in Washington District of Columbia, forts, ports, and needful buildings. De facto cannot exist in the presence of the de jure provisional government. A social compact, such as Article 1, Section 1, the lawful de jure provisional government on Oregon, when in a Congress assembled of, by, with, for the 32 states in our union, Oregon and 32 more. Then we add the 17 territories, each in a different color of law of a different de facto governance, with a different fraud for Kansas, Nevada, West Virginia, and so forth. So, Nikki helped figure out that our de jure Jural Assembly has all the authority to provide for the Electoral College, and we have all the authority to populate our provisional government. And I yield. Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. I have a document here. Shouldn't take long to read it. This is a follow-up on our actions with the U.S. Marshal Service, August the 1st, downtown Portland in the Marco Hatfield Federal Building. It starts out with our standard header, Oregon, comma, within the state of Oregon, without the state of Oregon, within the United States of America, the constitutional Republican form of government. Ronald Charles Vroman, Clerk of Court, General Delivery, Beaverton, Oregon, in brackets 97005 503-641-8375, docket number 08122023. This will all be on letterhead with watermark, signed, sealed, delivered, stamped, witness, the whole 9 yards. Notice to the agent is notice to the principal. Notice to the principal is notice to the agent. 2. The United States, to the Office of the United States Marshals, aka USMS, aka United States Marshal Service, of original jurisdiction of the United States of America's apostrophe S Constitution circa 1859 in the de jure jurisdiction guaranteed by our founding documents, specified below. Notice and demand, the notice, colon, no billet when defined as a needful position that needs to be filled, such as officer of the day, officer of the deck, officer of the watch, or a bailee, as is required constitutionally, can be abandoned. I have the need to know, and you are required to comply. Whatever iteration of the de facto that is in ascendance and or has the duty to our Article 3, Amendment 7 Civilian Court of Record must respond to this de jure demand from our lawful court. We do not claim jurisdiction, operate in the common law in on for cases of less than $20. Therefore, we have no judge. Demand, colon, establish liaison for our court and our marshal, Robert, quote, Bobby Graves, within the next 30 days. At the end of August, our encounter with the USMS, we will have incontrovertible evidence of the many 18 USC 3571 due process violations of 8 people on August the 1st, 2023, of our unalienable rights. This may be used as evidence with our grand jury. With full faith and credit, governing law is established in this document at this time to be Declaration of Independence, Articles of Confederation and Perpetual Union, Oregon's original Constitution circa 1859, and the United States of America's Constitution circa 1859, and ORCP 20A. Clearfield Doctrine, Accardi Doctrine, Ex parte Young, Ex parte Milligan, McCarran-Walters Act 1952, Judiciary Act 1789, Section 32, Judgment Nihil Dicet are all specifically called into this document. They are all governing law, which must be accepted. The current 13th and 14th Amendment are bogus and must be rejected. Take heed of the Blackstone commentaries. The DOJ is agent to the entity responsible for the enumerated requirements of Article 3, the one Supreme Court that must claim original jurisdiction to be a court. I would consider to be in jurisdiction when found in conjunction with Amendment 7 court. The DOJ has failed miserably in their responsibility. We must do it ourselves. We define the words we use. We decide our method of communications. This communique is not intended to mislead, defraud, deceive, or threaten in any way, and is submitted with good faith and clean hands. We do lawful, not legal, and this is our best effort. Living testimony, that's for me, and I've read it before, and it'll be on the document that I'm sure William will put a snapshot of or just show it and do the audio. And then it closes out with our standing close on Oregon without the state of Oregon and blah, blah. Then it says evidence. I love serendipity. Article 1, Section 1, natural rights inherent in people. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. That's us. 42 U.S. Code, 1987. Prosecution of violations of certain laws. The United States attorneys, marshals, and deputy marshals, the United States magistrate judges, appointed by the district and territorial courts, with power to arrest, imprison, or bail offenders, and every other officer who is especially empowered by the President, are authorized and required at the expense of the United States to institute prosecutions against all persons violating any of the provisions of Section 1990 of this title, or of Sections 5506 or 5516, 5518, and 5532 of the revised statutes, and to cause such persons to be arrested and imprisoned or bailed for trial before the court of the United States or the territorial court having cognizance of the offense. That's us. Then it gives a bunch of citations, and William will put them up. I'll show them if you want right there. There you go. Then this next one is 42 U.S. Code 1990. That's the one that it referred to. And it says marshals to obey precepts, refusing to receive or execute process. Every marshal and deputy marshal shall obey and execute all warrants or other process when directed to him, issued under the provisions of Section 1989 of this title. Every marshal and deputy marshal who refuses to receive any warrant or other process when tendered to him, issued in the pursuance of the provisions of this section, or refuses or neglects to use all proper means diligently to execute the same, shall be liable to a fine in the sum of $1,000 for the benefit of the party aggrieved thereby. Now, in the after action, oh, and here it gives the video of the after action from August the 1st and our encounter of our court with the U.S. Marshals. So there it is in the code. They're not allowed to do what he did. He broke his own rules. We know it. Now we have the document that proves to them we know it and they know it. That's incontrovertible evidence. And I yield. Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. I have a little over a half a page I'd like to read here. I think it's important. I use Black's Law 6, page 416. De facto is illegal and illegitimate, while de jure is legitimate and constitutional. The Confederation and Perpetual Union, styled the United States of America, was broken on the 24th of December, 1860, thus providing color of law, as they had no lawful way to proceed. Then martial law started 1861. It was codified by Lincoln's Executive Order 100, aka Lieber Code. It is still in effect and was updated by the U.S. Army 2016. After the conflagration between the several states of our Union, which ended in an armistice signed by two generals, the Union was never reconstituted. Thus, the disaster known as Reconstruction and the criminal administrations of Grant and those that followed him, including the Congress, that continued to operate in color of law to this day. We spoke to a former congressman and he said it. Yeah, he knows. They all know they are not a constitutional Republican form of government. Original jurisdiction, Black's Law, page 1099, arrived with the concept, probably from the Algonquin people of New England. The Algonquin tribe was huge. That men and women with their progeny were free, sovereign, without ruler or subjects. It took over a century for this to percolate through the consciousness of the immigrants from Europe. My family was Dutch. We arrived in 1664. When they wrote Article 3, they didn't get it right, and they had to add Amendment 7. That is original jurisdiction in common law, where a man can find remedy against the state. Looking for an Article 3 court for 18 months. I did that. One that would claim original jurisdiction over my 11 cases filed into the bogus Article 1 court of Portland, with no authority over a case between a man and the state. I have postal letters from the clerks of the Supreme Court and the U.S. Court of International Trade, New York, New York. They are not Article 3 that will claim original jurisdiction. Neither would they identify the Article 3 court, its location, or clerk. Mukini 303 adds additional information. If the court's name begins with the United States, it is not an Article 3 court. Next, we have Ex parte Milligan. It provides the method of removing martial law, Lieber Code, FEMA, from our from our area geographically, when there is a civilian court of record available. The Oregon Statewide Jural Assembly formed Article 1, Section 1. I ought to read that. Oh, I've read it enough times. July 10th, 2019, and notified with proof of service the U.S. DOJ, the U.S. Marshal Service, the FBI, the U.S. Marine Corps, the state of Oregon, aka State of Oregon, all caps, and we did it again June 8th, 2020. Now to all naysayers, of the industrial, military, judicial, legislative, executive, banker, bar, royalist, Nazi, communist, Muslim, Catholic, Jesuit, Khazarian, UN, pharmaceutical, medical, de facto, conspiracy complex. To all of you, minus the Georgia Guidestones. This is our best effort, and it is working without rebuttal. It is content over form. We are what we say we are. There is no way the de facto can continue to exist in the presence of the de jure constitutional Republican form of government on Oregon. If the DOJ, FBI, federal courts, U.S. Marshal Services, and the United States of Washington District of Columbia, Inc., and its subdivision, the state of Oregon, aka all caps state of Oregon, thought they could take us out, they would have over the last 5 years. We are several hundred strong with our de jure status, standing, jurisdiction, and law form. 6 grand juries, 5 Article 3, Amendment 7 courts, with 4 found guilty, bringing forth 4 times 38 prosecutors on Oregon in one case, 89 guilty times 38 prosecutors in another case, for a total of 3,534 presentments and verdicts in just 2 of the 5 cases, against 1 governor, 2 senators, 1 U.S. representative, and 89 Oregon legislators, all signed, sealed, stamped, witness with proof of service, and published at www.orsja.org. And I yield to any that can rebut this.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car. And he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.